Good afternoon, ladies and gentlemen. The college hosted the festival last night. Have joined to celebrate. Some professors convened to boost it and might do for some partnerships for your safety and prevention of possible misconduct. It must have been really encouraging to see a fraternity and feel of comradeship during the course of the event last night. There will probably be one of unforgettable experiences that could long make a move to aspire for young college days. We are virtually on the mid of this fall term. The week after the midterm exam would be administered. You stay on the notice of college midterm exam schedule and get yourself prepared for better answer and grades. You are now notified that the midterm exam of this class will be waived. Instead, you have to write a short research paper about the topic you are free to choose. But your topic needs to be related with the class discussion already rendered and expected to continue until the end of next week. Okay? During the exam week, this class would not close. The paper ready to be assessed would be turned in by 10th of November. You may simply put it in my mailbox or delivered in person at my office. The pages would be around 4 to 6 pages on A4 sheet. And either Korean or English is acceptable at your option. The deadline would be strictly enforced, but you can legitimately raise any excuse based on a justifiable cause. Illness, a job duty of a working student, or other unforeseen event perhaps could be a typical case in my previous experience. The paper would explain 35% of your final grade, and questions about the assignment and substitute for the midterm exam. Question? No? Okay. What is this? I've searched around if you can get more intimate with this class. I made 2 pictures. One is a Psy, and the other would be a Michael Jackson for later class purposes. I hope this could evoke your involvement in this class. But I'm not sure if it could be interesting. The attention of public in these days seems to highlight the great success of Gangnam Style. Gangnam Style. Although some music commentary predict one-hit syndrome, it is obviously remarkable the Korean artists made up the Billboard list around the world. The other recordings right now will soon get free from the current control status and would be made permissible on the public availability. Upon his frequency on the news media, I asked one peer how his name connotes. His business name is Psy, a fairly unusual name indeed. and I initially made a conjecture on its pronunciation only. If it were to come as abbreviation of citation or cipher, that would perhaps be that I have had my way in the scholarly profession. But I was amazed that he bore out his personality as psycho, that it had long been connoted in that indication. Psycho is slang for a person who is psychotic or psychopathic. The term is often considered offensive or derogatory. However, when used within a compound term such as psychology or psychotherapy, the word refers neutrally to the psyche, mind or soul. His intention would go in the first dimension according to his debut statement long years ago. Then we now stop at this point to deliberate how we could be developed in our personhood. Let's think about some cases where the mental state is disputed in the criminal proceedings. In other cases, like Psy, the vigor and concentration may lead to personal success and social contribution. If the case would be in the former, then it could be our topic later discussed in this class. Okay. Now we continue to review a complicity rule in the criminal context. The topic discussed in this class would not be in sectional order other than the discourse in a regular criminal law course. Actually, I exerted to get on the typicals of common law system that you may feel discursive in some cases, but may well be assuaged on the tight structure of a criminal law. Liability for crime is not limited to the person who actually commits the prescribed act. Rather, liability extends to anyone who has encouraged or assisted perpetration of the crime, a common law, who has hindered the apprehension of the perpetrator after commission of the offense. All such persons are regarded as parties to the crime and will be liable as if they themselves had committed the criminal act. In the common law classification of participation, the party rules would be deemed essential to govern in general. Under the common law, the parties to crime are carefully classified. Traditionally, these distinctions were primarily important for procedural purposes, but once the procedural limitations were overcome, all parties could be subjected to the same penalty. Firstly, we may think about parties to felonies. It includes four types. Let's see, first, principal in the first degree. Principal in the first degree are those who actually perpetrated crime by their own acts, by the acts of indecent human being, or by means of some inanimate agency. Thus, if A causes B, a child to pass a counterfeit note, B, because of his immaturity, cannot be held liable for his act. A, however, is a principal in the fourth degree because he accomplished the offense by use of an innocent agent. Principals in the second degree are those who either incite or abet the commission of the crime and who are actually or constructively present at the time of its commission. The person is constructively present when he assists the principal in the fourth degree at the very time the offense is committed, but from such a distance that he is not actually present. About the context of accessory with the two cases, accessory before the fact and accessory after the fact. Those who incite or abet the commission of a felony by another but are not actually or constructively present at the commission of the offense are accessories before the fact. Accordingly, this form of liability covers those who provide a pre-crime assistance or encouragement to the actual perpetrators. An accessory after the fact is one who receives, comforts, or assists another, knowing that the other has committed a felony in order to hinder the perpetrator's arrest, prosecution, or conviction. In this case, the court normally says that the wife is excluded in its scope. Under the common law, however, a wife could not be an accessory after the fact to crime committed by her husband. It is long history from the common law. The party rule is very significant. As noted above, the law parties has procedural significance at common law. Under the common law, under the common law rules of pleading, a person charged as an accessory could not be convicted upon proof that he was a principal. Similarly, one charged as a principal could not be convicted as an accessory. Of similar significance was the fact that an accessory could not be convicted unless the principal was convicted, although both could be convicted at the same trial if the principal's guilt was determined first. Moreover, an accessory could not be convicted of a higher offense than that for which the principal was convicted. The common law does not apply to the two degrees of principals. Therefore, one charged as a principal in second degree can be convicted despite the acquittal of the principal in the fourth degree, and even if the proof at trial showed him to be a principal in the fourth degree. In the case of misdemeanors, there will be no distinction among parties. Those who aid or incite the commission of misdemeanor are, of course, liable for the resulting crime at common law. However, no distinction is made between principals and accessories or between the degrees of principals. Moreover, as we have seen, there is no common law liability at all for aiding a misdemeanor, for aiding a misdemeanor after the commission of the offense. The rule of no distinction among parties will also apply to the case treason. Similarly, the distinctions among parties do not apply to treason. All participants are liable as principals. On the modern statutory scheme, those who incite or abet the commission of a crime are generally still guilty of the crime itself. However, a distinction is no longer drawn among the participation. Thus, for example, in many jurisdictions, all participants in the commission of a crime are regarded as principals. This rule is also adopted in a Korean jurisdiction. Similarly, the Model Penal Code provides that a person is guilty of an offense if he commits it by his own conduct or if it is committed by another for whose conduct the accused is legally accountable. One is legally accountable for the conduct of another if he causes an innocent person to engage in conduct constituting a crime, or if he is an accomplice to the conduct of the other person. An accomplice is one who solicits the commission of an offense, aids in its commission, or having a legal duty to prevent the commission of an offense, fails to make proper effort to prevent it. On the other hand, an accessory after the fact is often no longer deemed guilty of the crime committed by the principal. You now refer to the third chart. Whether a number of states reject this classification and treat hindering the arrest, a prosecution or conviction of a felon as a separate and distinct offense, which generally carries a lower penalty than the offense committed by the principal. We can see the effect of modern changes as twofold. First, there will be a few pleading and proof problems. And secondly, in normal cases, conviction of principal may not be necessary. The changes made by modern statutes substantially simplify procedural aspects of the law of complicity. For instance, it is no longer necessary to specify in the charge whether the defendant is guilty as an accessory or principal. Hence, there are no problems of variance between the pleading and proof. And although the statutes are interpreted in a variety of ways, many have been read to abolish the requirement that a principal be convicted before an accessory may be convicted. Thus, in many jurisdictions, one who otherwise would have been an accessory before the fact at common law may be convicted even if the actual perpetrator has been acquitted. The liability of those who may be responsible for crimes perpetrated by another because of their involvement in the offense presents special problems. This section considers the issues presented by accomplice liability. The liability of those participants who at common law would be principal in the second degree or accessories before the fact. For simplicity, these participants may be called insiders and abettors or accomplices. The chart shows the requirement for a criminal liability around inciting, abetting, and other cases of accomplice. First of all, it must be shown that the defendant encouraged or facilitated the common the commission of the offense. One abets the commission of an offense if he assists in its commission in any significant way. It need not be shown that without such aid, the perpetrator would have been unable to complete the crime. But perpetrator did not be aware of aid. There need not be any communication between the participants, nor need the actual perpetrator be aware that he is benefiting from the accessory's assistance. In some cases, omission may be considered as abetting. A mere failure to prevent the commission of an offense will not ordinarily constitute abetting. One who has knowledge that the crime is about to be committed but takes no steps to intervene will not, on that basis alone, incur criminal liability as an accomplice or otherwise, unless the defendant had the legal obligation to intervene. Quite apart from abetting, the commission of an offense, encouragement, even if not accompanied by any physical aid, is sufficient to render one an accomplice. However, encouragement by definition cannot exist unless the person sought to be encouraged is aware of the efforts. Therefore, one who merely attempts to encourage the commission of a crime is not an inciter if the perpetrator has no knowledge thereof. Present at the scene of the crime without more does not constitute incitement, but the result is contrary if by prior agreement one is present for purposes of rendering aid to the perpetrator, should such aid become necessary. This is sufficient encouragement, and so is enough to create an accomplice liability. I'd like to introduce two cases on accomplice liability. The first case would be Hicks versus United States, decided in 1893. In that case, appeal from a conviction for aiding and abetting a murder was made. Hicks, who was defendant, was charged with murder because he allegedly encouraged Roe by using gestures and verbal support to shoot and kill the deceased. The defendant was present at the shooting. He was convicted and appealed. The court held, in order to find defendant guilty, it must be shown that he actually intended the words used to help encourage the perpetrator of crime. Based on this position, the conviction of law court is reversed. Mental intent is a requisite element of the crime of aiding and abetting. The trial court erred in its instructions to the jury by not requiring a finding of defendant's intent. The court also instructed the jury that if defendant was present at the scene of the crime for the purpose of aiding a Roe, he is guilty even if he took no action. This is error. Mere presence in the absence of conspiracy or solicitation is not enough for accomplice liability. In Bailey versus United States, decided in 1969, appeal from conviction for robbery was made. Bailey, who was defendant, was hanging around with X and an unknown man. After a while, a defendant and X went to the loading ramp on the Central Market and stood around. When the bookkeeper, Lawson, came out with the day's bank deposit X took the deposit at gunpoint. At the moment, defendant was some 10 feet from the scene, walking away from X. Then X fled when a man who was in the area yelled, "Look, they are robbing him." Defendant was apprehended, but X never was. He was convicted of robbery for aiding and abetting the principal assailant. A defendant appealed. The court held a proof of guilty participation is necessary in addition to showing a defendant's unexplained presence with the principal assistant at the scene of crime. And the conviction was reversed and the case was remanded for acquittal. A sine qua non for aiding and abetting is guilty participation by the accused. A culpable purpose is essential. Presence is equated with aiding and abetting only when it is shown that it decidedly encourages or facilitates the unlawful deed, or where it stimulates others to assist in the criminal act, devise the spoils, and so forth. Here, there is no evidence that the defendant was the planner of the robbery, that he rendered assistance to X, or that he encouraged the robbery. Bare presence at the scene of the crime, even coupled with some prior association with the principal, is not enough to sustain a conviction. The fact that the defendant fled does not change matters. It is common knowledge that entire innocent persons will flee due to any number of reasons. Justice Bastina counter-argued that the totality of the evidence, more than adequately, the totality of the evidence shows more adequately that he was guilty beyond a reasonable doubt. This case demonstrates necessity of the prosecution's showing that the accused incited or abetted the principal. Mere presence with the principal is not sufficient to make one criminally liable. And also, a mens rea requirement is essential to find the accomplice to be criminally liable. Much confusion exists as to mental state required for accomplice liability. Basically, the issue is twofold: whether the accomplice must have the mens rea required for the crime, and secondly, whether she must also have intended that her actions have the effect of assisting or encouraging the successful completion of the crime. The authorities are in general code that an accessory must have the state of mind necessary to commit the crime by direct action, the mental state required for the perpetrator. In this context, we'll read 4 cases to have the basis. In a State versus a Graf decided in 1970, appeal from manslaughter conviction was made. Luz Graf was defendant, and husband Kenneth lived in a house on a lot adjacent to church. There was a dispute between the Grafs and the church as to where the boundary line was. One day, Mary Martin and his father, Robert Martin, went to the church to mow the grass. An altercation between the Martins and Grafs, including their son and dog, ensued. During the altercation, Kenneth stabbed both Larry and Robert. He was involved in the fray, pushing and pulling Robert. The encounter ended and Letty helped Lover to leave. Lover later died. He was convicted of manslaughter for aiding and abetting the killing. Defendant appealed, arguing that the trial court prejudicially failed to instruct the jury that to be guilty of manslaughter, defendant, knowing the unlawful intent of Kenneth, that intentionally aid and abet Kenneth in the killing. In this case, court held an aider and abettor must have the intent of aiding and abetting the principal in the commission of the charge there. For an aider and abettor to be guilty, she must have had the intent to aid and abet the principal in the unlawful act. Here, the trial court committed a reversible error in failing to instruct the jury. The defendant had to have the intent to aid and abet Kenneth in the killing. Morgan dissented, Justice Morgan dissented. He believes the instruction given to the jury did properly inform the jury that the defendant had to act intentionally. So he opposed the majority court opinion about the context of a jury instruction. In this case, defendant was clearly aiding and abetting Kenneth in the assault. On the other hand, there is considerable uncertainty as to manslaughter required in regard to the effect of accessory's action, the assistance or encouragement. All courts agree that one who had no contemplation that her acts would encourage or assist the perpetrator cannot be convicted as an accomplice. Beyond this, however, the result is not so clear. We have to think, must the accessory intend that the conduct have the effect of encouraging or assisting, or is it enough that she acted with knowledge that the conduct will promote or facilitate a crime? This kind of problem was posed in the case State versus Gladstone, decided in 1970. In this case, an appeal from conviction for aiding and abetting another in the lawful sale of marijuana was made. An undercover narcotics agent named Thompson went to Gladstone's apartment, who was defendant, and asked defendant to sell him some marijuana. Defendant responded that he did not have any, but the can did. At Thompson's request, the defendant drew a map of how to get to a Kent's residence. Thompson went there and bought 8 ounces of marijuana. He was convicted of aiding and abetting Kent in the sale of marijuana. Defendant appealed. The court held a defendant, an aider and abetter, a defendant is not an aider and abetter if he merely communicates that another might commit a criminal offense. According to the court opinion, to be an aider and abetter, one must associate himself in some manner with the criminal venture. Here, there was no evidence of any communications or agreements between defendant and Kent. It was not even established that they knew each other, nor was any evidence that a defendant encouraged Kent to commit the crime. There must be proof of a nexus between aider and abettor and other principles in order to sustain a conviction. Mere communication to the effect that someone might or probably would commit a criminal offense does not amount to aiding and abetting the offense. Justice Hamilton dissented, the intent required is that the aider and abettor have a conscious intent that his action will instigate, induce, procure, or encourage the perpetration of the primary crime. There was much circumstantial evidence that defendant and Kent were connected in the earlier when Thompson told Kent that defendant had sent him. Kent invited Thompson in and sold him the marijuana, and that a defendant had the requisite conscious intent to aid and abet the sale. In the last case, titled People versus Marshall, decided in 1961 by the Supreme Court of Michigan, the issue would be if a car owner is liable for killing resulting from his permitting a drunk to drive his car. It occurs very usually in also in our community. In this case, appeal for conviction for involuntary manslaughter was made. Marshall, who was defendant, gave the keys of his car to McCurry, who was drunk. McCurry, traveling in the wrong direction on the expressway, crashed head-on into a car driven by a Calderon. Both drivers were killed. Defendant was at home at the time. He was tried for involuntary manslaughter. After his conviction, he appealed. In this case, the court said the car owner is not liable. A criminal liability under the law is individual and personal. The state relied on Story versus United States, wherein a car owner was held liable for aiding and abetting a drunk by permitting him to take the wheel. That case is distinguishable since the driver was seated in the car at the time of the accident. So the case was decided in a different fact pattern. The accountability of the car owner must rest upon his complicity in the misconduct. Here, defendant did not counsel the killing, nor did the killing occur in the attempted achievement of some common enterprise. Thus, there is not sufficient connection between the killing and defendant to impose a criminal liability. This does not mean the defendant is absolved from civil liability. So the victim may be restituted from civil liability. It is separate a proceeding, and the result could not go in the same way. The court noted the defendant was guilty of misdemeanor for knowingly permitting an intoxicated person to drive the car. It did not stretch the same misdemeanor conduct to manslaughter by widening the traditional scope of aiding and abetting. In the case titled Pinkerton versus United States, decided in 1946, the court elaborated on the conspiracy-complicity relationship. In this fact, appeal from conviction for conspiracy to evade taxes was made. Two borrowers, a defendant and a W. What is this initial W? Are prosecuted for conspiracy and the commission of substantive crimes in violation of the Internal Revenue Code. They contended that because only a W committed the substantive offenses, he could not be held to be a conspirator, even though the substantive offenses were committed in furtherance of the conspiracy. And the court held evidence of direct participation in commission of a substantive offense is not necessary to sustain a conviction of conspiracy. Therefore, once involved in conspiracy, the acts done in furtherance of the conspiracy by any of its members become the acts of all of its members. There is no responsibility only when the substantive offense is not committed in furtherance of the conspiracy. It did not fall within the scope of the unlawful project or was merely a part of the ramifications of the plan, which could not reasonably be foreseen as a necessary or natural consequence of the unlawful agreement. Under the rule advanced in this, the leading case, each member of conspiracy is liable for those crimes committed by all other members which were a reasonably foreseeable result of the conspiracy and done in furtherance of it. And it is a very critical case in the context of a conspiracy and complicity relationship. It provides a basic rules to govern the ramification of many cases. There is some question as to the actual scope of liability of an accomplice, and substantially a great question as to what the scope of liability ought to be. Generally, an accessory may be held liable for all probable consequences, according to the traditional law. Thus, liability may be imposed not only for the offense incited or abetted, but for all crimes committed by the perpetrator, which were a reasonably foreseeable result of the contemplated crime. This rule was applied to the United States v. Carter, decided in 1971. In this case, the court ruled the felony murder rule, for the felony murder rule to apply, the killing not be in furtherance of a common design or purpose. Carter, a defendant, and Whiteside were riding in a cab in this case. Carter got the cab driver uptight, his arm around the driver's neck. Whiteside shot the driver twice, killing him. Apparently, Carter was a defendant, did not know Whiteside would shoot Cappy. The Cappy was robbed of his fares, $24.6. He was convicted of robbery and felony murder, and defendant appealed. In this case, it is clear that defendant was participating in a robbery. While it may be true that the killing was far from a defendant's mind, his participation in the robbery resulting in a killing made him guilty of first-degree murder, of which he was duly convicted. Justice Fye also concurs in the robbery conviction. He would reverse as the felony murder charge. The test should be he argued the test should be not whether the defendant aided and abetted the defendant in the crime from which the murder stems, but whether the murder was in furtherance of a common design or purpose. Upon the decision of this case, some states require participation in an inherently dangerous felony for the felony murder rule to apply. The district code required only any offense punishable by imprisonment in the penitentiary. We also could identify one more case about the traditional rule in the area of this law. The case name was a People versus Kessler, decided in 1934 in the state of Illinois. In this case, appeal from appellate court's reversal of conviction for attempted murder was made. Kessler, who was defendant, waited in a gateway car while two unarmed accomplices, Mars and Evany, entered the tavern for the purpose of robbing it. While inside, they were surprised by the owner. One of the two shot and wounded the owner with a gun taken during the robbery. Later, while fleeing on foot, one of the two shot at a pursuing police officer. The trial in court found a defendant guilty of robbery and attempted murder. The intermediate appellate court reversed the attempted murder conviction. The state appealed. The court held a defendant is liable for whatever is done in furtherance of the common criminal design. Therefore, when one voluntarily enters a hazardous criminal activity, the act of one is the act of all, and all are equally responsible. This position is also adopted in a Korean criminal code. With the mere presence or negative acquiescence, it is not necessary to have actively participated in the overt criminal act. Whatever is done in the furtherance of the common criminal design is the act of making each person guilty of the crime. Applying the common design law to this case, we affirm the trial court conviction for attempted murder. We may find a dissenting opinion filed by a Justice Gordas. He argued the attempted murder statute did not make the defendant accountable under the facts of this case. So there seems to be some difficult interpretive question posed by the statute itself. The aiding and abetting statute requires proof of an intent to promote or facilitate the commission of the substantive offense. And he found here the substantive offense is attempted murder. And he also furthers the attempt requires a specific criminal intent. And in this case, he saw that it was not shown that the defendant had the specific criminal intent to attempt a murder. The dissenting opinion noted that if someone had been killed by the shooting, the defendant would have been accountable on the other provisions of the criminal code. Against this majority doctrine, we can see a minority rule, which supposed the criminal liability has to be limited to contemporary crimes. Some courts and commentators have argued that the traditional rule is unjust and inconsistent with well-accepted notions of a criminal liability. They contend that such a broad rule exposes an accessory to liability without requiring a culpable state of mind, and therefore is inconsistent with mens rea principles and the policy upon which they are based. Accordingly, a minority of courts follow the model penal code position, which rejects the traditional rule. Under this approach, an accessory is liable only for those crimes of the perpetrator that he incited or abetted. So it is a complicated area of a criminal law that the jurors need to be scrupulous about the rules and details of facts proven in court law. And in order to impose a criminal liability, perpetrator must have committed a crime. So the general rule is that the person incited or abetted must be guilty of the offense. This traditional rule was dealt in the case titled People v. Taylor, decided in 1974. In this case, appeal from murder conviction was made. Taylor, who was a defendant along with Daniels and Smith, robbed West. Defendant was sitting in the gateway car at the time the other two actually robbed West. Smith was shot to death. In order to convict defendant, it had to prove that either Smith or Daniels harbored malice. At Daniels' trial, the state failed to establish that Daniels entertained the requisite malice. Subsequently, defendant was convicted of robbery and murder. On appeal, defendant argued that the doctrine of collateral estoppel precludes the state from litigating the issue of Daniels' malice, and hence the murder conviction had to be reversed. Based upon this fact, the court held a defendant may not be held vicariously liable for the act of a previously acquitted a court defendant. The court instructed the collateral estoppel in the context of this fact pattern. Collateral estoppel about litigation if the issue necessarily decided at the prior trial is identical to the current trial. Secondly, the previous trial resulted in a judgment on the merits. And thirdly, the party against whom collateral estoppel is sought was a party or in privity with a party at the prior trial. The court found that the first two of the above requirements are fully satisfied. The question is whether the third requirement has been fulfilled. Collateral estoppel is constitutionally compelled in criminal cases when the same defendant was involved in both trials. Some courts, however, refused to apply the doctrine if the defendant was not involved in the prior trial. That is exactly the issue posed in this case. In order to first promote judicial economy by preventing repetitive litigation, secondly, prevent a person from being harassed by vexatious litigation, And thirdly, most importantly, prevent inconsistent judgments which undermine the integrity of the judicial system. These are three prime goals that the collateral estoppel are based upon. Then the court saw that the vicarious liability would not be extended to co-defendants of previously acquitted defendants. And the court also confirmed that as to identity of parties, the state had the opportunity to litigate the issue of Daniels and A. Smith's conduct fully in Daniel's trial. This reasoning, of course, led to the result as we have seen previously. However, it is just a traditional rule. We see the modern rule is contra. The modern rule was dealt in United States versus Brennan, decided in 1973. In this case, the court held an aider and abettor can be criminally liable if the principal is acquitted. This case was developed in the context of appeal from conviction for aiding and abetting a theft. Atolls were charged with having stolen 950 cases of scotch from a buyer. Atolls was a truck driver who presented papers to pick up the scotch. Brian, who was a defendant, was charged with aiding and abetting Atolls. At trial, Atolls was found not guilty, since the judge found it had not been proved beyond a reasonable doubt that Atolls was anything more than this dope. Defendant was found guilty for having aided and abetted Atolls by furnishing certain documents. Defendant appealed. The court decided a defendant cannot be criminally liable for aiding and abetting unless proof established that the substantive crime was committed by someone. Here, Atolls removed the goods with a false document. The fact that he lacked criminal intent does not mean there was no proof of the crime. The court viewed the distinction between an aider and abettor and a principal was largely semantic. When one person plans the crime and the other person actually commits the criminal act, such as in this case. A federal code makes aiders and abettors punishable as principals. There is no longer the common law distinction between principals and accessories before and after the fact. The statute makes them all principals, whether the offense is a felony or misdemeanor. This case involves some of a Fifth Amendment issue, and the court viewed the Fifth Amendment prohibits amending an indictment either by motion or implicitly by presenting proof of crime different from the charge. This doctrine was also imported in the criminal procedure law of South Korea. The rule adopted in this regard by the United States Supreme Court has two prongs. Certain amendments are per se reversible. Second, others are reversible only if prejudicial to the defendant. The general rule is that the accused must be informed of the charges against him and must be protected from another prosecution for the same offense. So the course of here, acquittal and trial court would have protected defendant from the trial for the whiskey theft. Further, defendant was informed in the indictment that he was charged with aiding and abetting actuals in the theft of 950 cases of whiskey from Paye, 80 in Philadelphia on May 11, 1970. Actually, both are engaged in a series of theft throughout long times. The proof conformed to this charge. There is no difference between the crime charged and proven. The court finally affirmed the conviction of lower court. Justice Gibbons size and R. Digit dissented. When the grand jury charges one offense, the trial court may not try another. This is what the majority has authorized, according to the dissent. Now we review a special defenses to accomplish liability. And two contexts were described in the chart. First, you can see withdrawal, and the case relating to withdrawal defense State versus Thomas, and Queen versus Tyrrell, decided long years ago, 1893, presents one other context of defenses available to accomplish liability. One who has encouraged or assisted the commission of crime may escape liability as an accessory by making an effective and timely withdrawal. The requirements for legally effective withdrawal differ somewhat with the nature of the accessory's initial action. However, in all cases, the withdrawal must take place before the chain of events leading to crime, has progressed so far as to become unstoppable. The situation might be on a communicated renunciation. If the initial action consists only of inciting, a legally effective withdrawal may be accomplished by communicating a renunciation of the crime to the perpetrator. This rule was applied to the case titled State versus Thomas, decided in 1976. The case was developed from the appeal from a forced murder conviction. The victim and his partner had aided at the scene of an arrest. Thomas was defendant, and two other young men, Janet and Cheatham, had gone to a rooftop to, in Janet's words, shoot cops. Janet shot and killed Bonacor. At trial, defendant admitted going to the roof, but alleged that he had left the roof after seeing Janet's guns and before the fatal shooting. Defendant was convicted of forced murder for aiding and abetting Janet. and defendant appealed. The court decided that an aider and abettor must communicate with his withdrawal in order for his withdrawal to relieve him of a criminal liability. The court opined a presence at the scene of crime is not essential to the crime of aiding and abetting. This is the plain rule reviewed in the first of this class. Thus, in fact, a defendant was not on the roof at the time of the shooting. That alone does not absolve him from criminal liability. It is clear that the trial judge found that he went to the roof to shoot cops, a criminal intent. Further, an aider and abettor cannot escape a criminal liability simply by fleeing the scene shortly before the crime occurs. In addition, the fact of withdrawal has to be communicated to the other conspirators. The communication requirement gives the co-conspirators a reasonable opportunity to follow his example and refrain from the criminal act. It is known also to serve the critical public policy about a reduction of more extensive crimes. Here, at best, the defendant left shortly before the shooting without communicating his withdrawal. This is not sufficient to relieve him of criminal liability. As a code by this case, some states have enacted laws requiring, in addition to communicating withdrawal, the complete renunciation of the criminal purpose. And one other context may be is surrounding the countermanding a prior aid on the part of an abettor. If the initial action consisted of abetting, physically assisting commission of the crime, renunciation alone is not enough. The abettor must act to render whatever assistance is given ineffective. And it is helpful to see the model code provisions about the withdrawal requirement. On the model penal code section 206, an accomplice may withdraw by wholly depriving his prior assistance of its effectiveness. Alternatively, he may do one of the following. For one, it has two prongs of context. One involves a notification of authorities, and the other strand goes to the effort to prevent offense. And no matter what form of assistance or encouragement was initially provided, a withdrawal will be effective if timely warning of the perpetrator's plan is given to law enforcement authorities. And additionally, an accomplice may escape liability by making a proper effort to prevent commission of the offense. Some conduct is made criminal for the primary purpose of protecting a certain person so to be in need of special protection. Accordingly, one who incites or abets the commission of such a crime and who is also within the class of persons to be protected will not be liable as an accessory. It is a little special circumstances involved in the law of accessory. In Quill versus Terrell, decided in 1893, Terrell, who was defendant, was convicted of aiding and abetting a man who statutorily raped her. She was a prostitute and had consented to sexual intercourse. Following her conviction, a defendant appealed. The court found a minor female may not be an aider or abetter of a man who statutorily rapes her. The statute was designed to deter the male. Therefore, he should be guilty even though the female consented. But if the purpose of the statute is to prevent intercourse, the consenting woman should also be guilty. This case raises the victim theory that one cannot be convicted of perpetrating crime against oneself or of aiding or abetting such a crime against oneself. Possibly, however, the idea with statutory rape is simply that the legislature has drawn a line and indicated that the females under 18 do not have the capacity to form the necessary intent to be held guilty. Furthermore, if the female is guilty of aiding and abetting, then she is an accomplice, and this creates an evidence problem, since the testimony of an accomplice cannot alone convict the defendant. Furthermore, since the testimony would make a criminal, the female would refuse to testify at all. So, do you agree that the minor female has to be acquitted because she was also a victim? Now we return to the general theory of a criminal law about the defenses normally available in the criminal proceedings. I've classed 5 elements that are practically important in the context of a criminal defense lawyers. Which includes affirmative criminal defense and the insanity defense, coercion and duress, abandonment and withdrawal. And I'd like to show other categories of a criminal defenses. If you haven't been accused of crime, you will have to appear in court. The accused in this situation is known as the defendant. As the defendant, you and your criminal attorney will likely want to establish some sort of a criminal defense to prevent a guilty verdict. A criminal defense is a strategic argument that attempts to challenge the validity and sufficiency of the prosecution's evidence. The prosecution is the party trying to prove the criminal charges against you. Some criminal defenses attempt to strike down the prosecution's evidence by showing that it is false. It is generally called an affirmative criminal defense. However, there are a number of types of defenses that accept some of the prosecution's evidence as true. These defenses affirmative defenses require that the defendant, along with his or criminal attorney, produce evidence in support of the defense. For example, say you have been charged with first-degree murder. First-degree murder is when you plan the murder beforehand. You and your attorney may choose to produce an alibi witness. An alibi witness is someone who testifies that you could not have committed the alleged crime. In this example, the alibi is defense. The type of defense that you and your attorney choose to pursue will depend in part on the crime you are accused of committing, as well as the evidence available to you. And you and your criminal attorney may consider the insanity defense. Made popular by television shows and movies, the insanity defense is not actually used frequently, nor is it often successful. This defense states that you committed the alleged crime, but did not know that what you did was wrong. To successfully use the insanity defense, you must have had several mental disease or defect at the time the crime was committed. This context would be reviewed in more details later in this class. You and your attorney must present clear and convincing evidence that you have such a mental disease or defect, and that this disease or defect resulted in your not understanding that your action was wrong. Relying on the insanity defense can be risky. By using it, you are admitting that you committed a crime. This means that if the jury rejects your insanity defense, it will likely find you guilty. Before using this criminal defense, you normally need to consult with a criminal lawyer. The other class would involve the situation of coercion and duress. Coercion and duress is an affirmative criminal defense that basically says you were forced to commit a crime because you were threatened with unlawful force. This unlawful force does not have to actually occur. Merely the threat of unlawful force can be enough to satisfy the coercion defense. The force or threat of force does not have to be threatened against the individual accused of the crime. Rather, it could have been used against or threatened against another individual, such as a family member. The coercion and duress defense cannot be invoked if your reckless actions put you in the situation that caused duress. For example, if you're to take part in a drug deal, which then led you to become subjected to unlawful force, that then led you to commit another crime, such as robbery, you would not be able to use this criminal defense successfully. And the fourth category would be abandonment and withdrawal. Abandonment and withdrawal is another type of criminal defense available to defendants. This defense is also referred to renunciation. This defense basically states that you are going to commit a crime or be an accomplice to crime, but then decided to abandon any involvement. It is technically an affirmative defense, so you and your attorney must show evidence to prove abandonment occurred. In addition, for the abandonment and withdrawal defense to be effective, your actions prior to withdrawing from the crime must not have in any way contributed to crime, or you must have notified the police in advance of the crime. there are a number of other criminal defenses that a defendant can invoke. Some of the most common criminal defenses include a self-defense, consent, intoxication, and statute of limitations. The criminal defense you choose to use will depend on the crime you are charged with and the evidence you have at your disposal. Whether you have a federal criminal attorney or a state criminal attorney or a public defender, you will want to work on your defense strategy with your attorney. This is the context. It matters with the jurisdiction of the United States, but the advice with the potential of being applied to the Korean cases either. A criminal defendant may have a mental disease or defect that makes impossible his participation in the trial. This incompetence is a separate issue from any alleged mental disease or defect existing at the time of the crime. Incompetency to stand trial is not a defense. It does, however, require a postponement of proceedings until the defendant is competent to stand trial. Incompetence may also arise at the sentencing proceeding. So now we like to review some of laws involving a criminal defense, including a mental disease, a chemical dependence, or a situation involving intoxication and influence, and so forth. Fourthly, we are now faced with the issue of competence to stand trial. The process of Senate hearings was debated in a Pay versus Robinson decided in 1966. In this case, the court held a hearing must be held prior to trial if the defendants then present mental capacity to stand trial is endowed. So it is a fairly stressful issue to resolve if the accused is competent to stand trial. It is a matter considered before the other kind of defenses discussed later in class. In this case, a petition for writ of habeas corpus was filed. And Robinson, who was a defendant, had an extremely long history of mental disturbances and the previous served 4 years for killing his 18-month-old child. One day, the defendant went to the restaurant and shot his common law wife to death. At trial, 4 witnesses testify as to this defendant's insanity. Even the prosecution mentioned to the judge that possibly a certain expert witness should be called to testify on the issue of defendant's insanity. The judge replied, "You have enough in the record." "No, I don't think you need." In this case, this means an expert witness. The defendant was convicted. The state Supreme Court affirmed the conviction, and the defendant then sought habeas corpus relief. We now see the essence of a court opinion. On appeal, the state insists the defendant waived the defense of his incompetence to stand trial by failing to demand a jury trial as per a state law. That argument is rejected. It is contradictory to say the defendant may have been incompetent, but he was competent to waive this defense. With this record, we cannot say that a defendant waived the defense of incompetence to stand trial. Evidence introduced at trial on this behalf entitled him to trial on this issue, which means defendant was deprived of a due process. The state suggests that a hearing be had now on the issue of defendant's incompetence at the time of the trial, rather than a new trial being had. We have previously emphasized the difficulty of retrospectively determining an accused's competence to stand trial. Thus, writ of habeas corpus will issue unless defendant is given a new trial within a reasonable time. In the dissenting opinion, Justice Harang and Black stated, the facts known to the trial judge did not suggest defendant's incompetence to stand trial. The bizarre episodes in defendant's life suggested intermittent insanity. Defendant's arguments on this point were tempered by the state's counter-arguments. The remarks by expert witness as to defendant's present insanity had reference to defendant's responsibility for the killing, not his incapacity at time of trial. According to the dissenting opinion, there was a positive evidence at trial of defendant's then present sanity. But the dissent sustained that the defendant's own attorneys never suggest that the defendant was incompetent to stand trial. In this case, the dissent does not disagree with the rule of law announced by the court, but the rule is as applied to the facts in the case. A defendant may not be held criminally liable if, at the time of the crime, he was so impaired by mental disease or defect as to be insane within the meaning of the law. The notion of insanity refers to a defendant's inability to engage in morally reprehensible behavior or to understand what he or she is doing. It differs from diminished capacity, which may be used as a defense to the element of manslaughter. So it is an affirmative defense indeed, as distinguishable from a diminished capacity. And in this area of law, we can find a very influential 4 or 5 test rules evolved in the context of a United States criminal jurisdiction, and it actually offers a critical lessons to the following jurisdiction of its criminal system. So, those would be a Magnet rule, which is a very traditional approach, and this rule is still used in many American jurisdictions. on the Manhattan test, the defendant is to be acquitted by reason of insanity only if at the time of the committing of the act he was laboring under such a defect of reason from disease of mind as not to know the nature and quality of the act he was doing, or if he did know that he did not know he was doing what was wrong. And there would be some problems about the definition of wrong and the nature and quality of the act and so forth, and that kind of issue would be disputed in Manhattan case itself, decided in 1843. And the court also developed an irresistible impulse rule for some of state jurisdictions. The defendant is, in this rule, the defendant is entitled to an acquittal if commission of the crime was caused by an insane impulse which controlled her will. And it actually operates as an alternative to Manhattan in many cases. And on this test, sudden loss of control is not required to criminalize the accused. And we can find a Durham rule, a third formulation of insanity defense. Yeah. Okay, that's fine. And therefore, I like to notify that the midterm exam would be waived, as I stated in the earlier of this class. And I advise you need to attend this class during the exam week. And we would get further on the insanity defense in next class. Okay, that will be all for this class. And see you in the next class.